We turn now to David Begnaud on the phone in Charlotte. David.
Hi there. I don't think you're going to see that video of the police body camera. There was a law signed by the governor in July, and it's going to take effect October 1st, which says the public is not entitled to see the body camera footage. The only person who can see it is the person who's on the body camera, and if they're deceased, their family has to go to court to get it. I don't think you're ever going to see it.
We know that civil rights activists are calling for an economic boycott of Charlotte, David. They're urging protesters, you got to stay calm. But what's been the reaction from the community so far?
Well, you know, it all started with a Facebook Live video after the shooting yesterday. So there was an officer-involved shooting, and then a young woman saying that she was the daughter of Mr. Scott got on Facebook and in an expletive-laced rant for about an hour went on to just raise hell and high water, saying that her dad had been killed and that he was sitting in his car and that he was disabled. And this Facebook Live video was seen by thousands of people. I think nearly 500,000 views is what it has right now. So what you saw is a public outrage that was generated by what a lot of people saw on Facebook. And a short time after that, there were these protests. For the most part, they were peaceful. People were marching in the streets, and then it turned violent. Bottles were thrown at officers. 16 officers were hospitalized, non-life-threatening injuries. Police moved in with tear gas. There was looting of a Walmart store. Protesters stormed Interstate 85, started a fire on the interstate. It was a wild night.
All right, David Begnaud reporting for us. Thank you, David.
And for more on the legal arguments in this case, we're joined over the phone by CBS News legal analyst Rikki Klieman. Rikki, thank you for joining us. We know the ACLU is calling on Charlotte police to release the video from the shooting, but is the department legally obligated to do that?
No, not at all. First of all, David Begnaud was exactly right about the state of the law. But in addition to that, there really has never been an obligation on the part of police departments to immediately release video when there is a pending investigation of an officer-involved shooting. What we have found in recent years, particularly since Ferguson, Missouri, is the whole idea of police departments releasing video voluntarily, particularly if a video would seem to support the officer's point of view, rather than just release these videos willy-nilly. What happened, as we may remember in Chicago, with the case of LaCon McDonald, is that video not only was not released initially, it was basically buried for a year. That I don't expect to happen. This is not a question of burying a video. This is a question of releasing a video when the time is right. And here you're going to have a full investigation, according to the police earlier today, which I would expect, of this officer-involved shooting. And until that investigation is complete, I do not expect any video would be released. And I don't think the ACLU, in light of what David reported, and I agree with, the ACLU cannot force that video to be released immediately.
Rikki, there was a 1989 Supreme Court decision, Graham versus Connor, which ruled that the use of force must be judged from the perspective of a reasonable officer on the scene rather than with 2020 vision, 2020 hindsight. So a lot of people now have interpreted that to mean that police officers are generally, I say, going to be given the benefit of the doubt because the officer can say, look, in my reasonable estimation, I thought that my life was being threatened, or perhaps this suspect wasn't going to drop a gun, or I thought they were reaching for something. Is that how a lot of people have said that perhaps that it may be time to revisit that decision?
Well, I don't expect any decision of the United States Supreme Court to be revisited unless there is a case that goes up to the United States Supreme Court involving an officer-involved shooting. And at least right now, I don't know of any. Perhaps there are some that are percolating on their way up there. But beyond that, we have to remember something, Vlad. Laws of self-defense for citizens, as well as for police officers, are set by each state. They may have a little bit of a difference from state to state, but ordinarily what we are looking at could be either or both the objective view, which is what would a reasonable police officer in the shoes of this officer feel, think, react, and, depending on the state, subjectively, what did this officer think, feel, do at the time of these events? So we have an objective test, we have a subjective test. It depends on what state that you're in. I don't believe that saying that if you read the language that you just repeated from the United States Supreme Court decision, that means the police officer gets the benefit of the doubt. I don't think that that's what the jury instruction was meant to say. I mean, you have to always look at the totality of the circumstances of what any person feels, perceives, and what they think they will do at that moment in time. And the overlaying factor is that only police officers, and of course the military, are allowed under the law to be able to use deadly force in the way that they do. So in that sense, we've given police officers more leeway, and of course we have, because their job is to protect society. But I don't think even that instruction from the United States Supreme Court with approval means that a police officer just simply says, look, I felt that my life was in danger, and therefore I'm entitled to shoot. It is never that simple. You must look at the totality of the circumstances.
All right, Rikki Klieman, always great to have your insights, Rikki. Thank you.
Thank you.